This is the session to discuss reforming legal aid. How can costs be cut without harming access to justice? It is sponsored by. It is run by Policy Exchange. It is sponsored by the Bar Council and Clifford Chance. And we are going to have each of our speakers speaking for about 5 minutes on that subject to allow plenty of time for discussion. The meeting will go on until sometime between 1:30 and 1:45. There are a few sandwiches and teas and so on for those of you who can't last that long without anything to eat or drink. Without further ado, you can see who the speakers are. I'll introduce them briefly now. The first speaker is going to be the Minister at the Ministry of Justice, the Minister responsible for reforming legal aid, Djanogly MP. Then we'll have Steve Hynes, Director of the Legal Action Group, who will respond to anything the Minister is prepared to tell us about his plans. Then I think we'll go to Peter Lodder, QC, Vice Chairman of the Bar. And finally, Michael Smyth, CBE, Head of Public Policy at Clifford Chance, soon to retire, sadly, from that vital role, completely irreplaceable, but he will be moving on to new and exciting things. But first of all, on that subject, Jonathan Djanogly at the Ministry of Justice.
Thank you. It's a pleasure to be speaking with Policy Exchange on the important topic of reforming legal aid. And to put it in context, let me just start by giving you the context that you've probably been hearing at a lot of fringes in the conference, which is the national situation, the fact that the last Labour government beggared the country, left us in huge amounts of debt, and as the Chancellor announced from the podium yesterday, and as he announced at the budget statement, there are going to have to be cuts. We're going to have to cut our cloth accordingly, and justice is not a ring-fenced department. Now, I can't tell you what the figures are going to be in a few weeks' time, October the 20th, but when he spoke from the dispatch box on the budget, he mentioned the figure of 25%. And if I tell you that our budget in justice is around £9.5 billion, and that we spend £2.2 billion on legal aid at the moment, then you can sort of get some idea as to the level of savings that we're talking about. Very significant indeed. Of that 2.2 billion on legal aid, about 1.2 is criminal and about £1 billion is civil. I would point out that we are now spending double in real terms what we spent on legal aid 20 years ago. And if you look at the international comparators, and I admit that it's hard to make direct comparatives. We had this debate yesterday, but let me give you the international comparators. That it's £2.50 per head in Spain, it's £3 per head in France, it's £5 per head in Germany, in Sweden £11 a head, New Zealand also common law £11 a head, Great Britain we are spending £38 per head of population on legal aid. And what was created in 1949 as basically a safety net system has morphed over the decades into something very much more complicated. And people ask, well, why is the spending so much higher? Why do we have this complicated system? And there are many reasons for that. We do have more cases per capita being funded in this country. If you, for instance, go to France, you have to go through a pretty rigorous administrative process in order to get support from the state. We have higher spending per case in this country. That is partly as a result of having an adversarial system rather than an inquisitorial system, but it is a fact that it is much more expensive. We have more criminal suspects being brought to court in this country than in other countries, and then more of them are actually given legal aid afterwards. On top of that, it's not just that the system is too expensive, it's also too complicated. And since 1949, we've had a layer upon layer of, firstly, increase of scope, increase of complexity. A lot of legal aid is, of course, it's not based at the moment on competitive tendering. A lot of it is based on historical conventions as much as practicality. Of course, this historical split that we have in this country between the bar and solicitors. But it goes much deeper than that. I found out the other day that you get higher payments for legal aid, criminal legal aid for a murder trial than you do for other serious crimes like rape, for instance. Why? I'm not quite sure. I think it's something to do with the historical fact that murder was a capital offence, perhaps. In fraud in this country, legal aid is paid by value, no matter what the complexity is. On top of that, I think it would be fair to say that the system over a long period of time has been pretty poorly administered. Firstly by the legal profession, and in more recent years by the LSC. I have to say that as a minister dealing with the LSE on a day-to-day basis, I have been very impressed by their commitment to sorting out a lot of the historical problems. But the fact remains that their accounts were qualified last year. Too many magistrates' court cases are going to the Crown Court, and there are actually administrative issues as well within the court system that we deal with. That means that cheap summary justice is often unnecessarily being replaced by expensive jury trials. I think it would also be wrong to say that the last government ignored this issue. In fact, if you look at the facts on legal aid, they put in place consultations on no less than 30 occasions in a 5-year period. So it's not like they ignored it, but they tended to look at individual specific issues. They tended to silo issues rather than looking at across the board. And what it tended to end up as was a series of salami slicing measures on budgets rather than a comprehensive, thoughtful review of the position overall. And that is why we are very keen to not go down that route again, and which is why when we announced in July that we were having a comprehensive review of legal aid, we said that it wouldn't be another external review. It was going to be an internal review. It was going to be assessing the information that was already out there, and we will be announcing in the autumn, i.e. very soon. That consultation paper, I can tell you, is a total review. It's going to be looking at scope, it's going to be looking at eligibility, it's going to be looking at mechanics, and indeed how best to merge the LSC with the MOJ. The review is going to take into account financial constraints, interest of justice implications, access to justice implications, public interest implications. But I would say that it is going to be very much more than just a savings exercise. And the starting point is not going to be how much we should be paying legal aid practitioners, or indeed how many legal aid practitioners there should be. The starting point is going to be what do we need to do to reform the system to create a system where vulnerable people have legal representation. So, just to end, I fully appreciate that solicitors and barristers have had a hard time in recent years. But I would also point out that it's not just legal aid solicitors and barristers that have had a hard time in recent years. It's been a hard time for the profession generally. And we are, I believe, approaching a time of dramatic change in the legal market for reasons that go beyond the scope of this of legal aid per se, but we can discuss if you wish. And legal aid is not going to be immune to those changes. But given what I have seen so far, I do believe that change is required and is long overdue.
Thank you very much indeed. Steve Hynes, if you'd like to respond to the Minister's proposals.
Well, my first response is that he was quite light on proposals, Jonathan, but I wouldn't expect any advance. Clearly there's going to be a green paper coming out in a matter of weeks. Responding first of all to international comparisons, I mean, this is a well-trod path in the legal aid debate. We had this from New Labour, and in fact, in their time, they commissioned a very good, comprehensive report on international comparisons, particularly in European countries. And as the Minister's already alluded to, what that found was, yes, there are dramatically different costs, £38 in this country, £3 in France, £5 in Germany. But then when you took the whole civil justice systems together and criminal justice systems together, what you find, particularly in the inquisitorial type system in France and Germany and other comparable European neighbours, is actually spending is similar levels to the UK. So the international comparisons, yes, I'd expect them in the political debate to come on legal aid, but I don't think it's going to be a happy hunting ground to justify the cuts in legal aid. However, it is important to state that yes, our system, there are costs within it. The Minister's already said there are sort of confounding costs, such as the cost of fraud trials and how criminal fees are calculated. Again, the previous government did a lot of work around this, and as the Minister has said, they could be accused of salami slicing. The problem with legal aid is that when you get down to the detail of legal aid, you have to talk about fees, you have to talk about what you're paying for, and very often it's what you're paying the lawyers in the system. Now, LAG would be the first to argue access to justice and legal aid is not about the lawyers, it's not about the number of law firms, though that the numbers can be important to ensure access to justice. It's not even about the numbers of barristers in the system. I'm sorry to be rude to one of our co-sponsors, but it's about ensuring access to justice, and it's like the Minister said in one of his closing remarks. That's what we have to keep focused on. And indeed, I've got to say that I'm certainly expecting a sort of continuity in policy, albeit it's very heartening to say that the coalition government wants to look at the whole system. But it will come down to having to look at certainly those policy areas and those areas around fees that have been looked at before. I'll give a couple of examples of that. First of all, there was the Carter report. And in the forthcoming book that we're producing, sorry about the plug there, but we will go through the sorry history of Carter and the Carter reforms. The last government, for various political reasons, it's got to be said, didn't take the Carter reforms forward, and particularly on the criminal side of legal aid. Now, there are potentials. There are certainly a potential for some savings on the criminal side of the system, particularly if the Carter reforms are implemented. There is a downside of that, which certainly LAG will expose if that is one of the options. But the other option around Carter is the reduction in the numbers of suppliers and increasing the volume of work for the suppliers that stay in the system. There is the potential to make savings of scale, and certainly if some solicitors are to be believed, there are savings to be made in fees because of those volumes of savings that you get. Now, this is very much detail, but again, you have to start off from the first principle if the legal aid system is about access to justice, and you have to ensure that you're not skewed in your analysis about what the legal profession wants and what firms particularly want. Moving on, the other big area that the last government looked at, which I know that the Minister is looking at, is family law. This illustrates, I think, one of the major points in the legal aid system. You can't look at legal aid as an isolated budget. You have to look at it in its entirety with the rest of the civil justice system and the criminal justice system. And nowhere illustrates that better than family law. The Minister part of his portfolio is to look at reforming the family court system. And that inevitably means that you have to look at the system in its whole, you have to look at law reform, you have to look at the procedures that are adopted within it. And I don't think anybody, and there'll be hopefully time for questions afterwards, would agree, that not agree in this room, that the family court system is in a mess. It's a river of human misery, to quote one of the family division judges, and it needs reforming. And certainly a part of that, we can look at reforming within the legal aid system. Going back to what the last government looked at, we know that they looked at options around taking out of scope various areas of family law that aren't essential. The number one essential area would be public law children. Again, I would have thought there's going to be consensus in this room around that. There are other areas such as divorce, ancillary relief, the money matters in marriage, where I think there's not going to be the same sort of degree of public support for other areas of the legal aid system. That said, there are alternatives. In family law, one of the alternatives perhaps for the legal aid system is to look at a loan system, either in a privatised system or in a semi-state controlled system, where people draw down on loans to finance the financial aspects of a relationship breakup. I think that might sound a bit left field, but actually, in reality, much of the family law legal aid system, that's how it works at the moment. The final couple of points I'd like to make really is it is encouraging, though we have had a lot of reviews of legal aid, that this government wants to look at the system in its totality. And the soundbite has been repeated a number of times. They don't want to look at salami slicing the system. And certainly I agree with that entirely. However, you have to look at legal aid around its first principles. And certainly from LAG's perspective, the first principles of legal aid actually, it's around equality before the law. And legal aid started at the turn of the last century because it was made available in murder trials. And I don't think, again, that ultimately the public, there would not be a consensus saying that if you're accused of a serious criminal offence, then you need the best advocacy, you need to ensure equality before the law. Also, I'd say, increasingly over the last 50 years, legal aid has been about civil liberties. It's been about the relationship between the individual, the state, and other interests, let's say corporate interests, to ensure that the individual can enforce rights. Now, that doesn't go down well in some quarters, but I actually think that you go back and you look at the history of this country and its legal system, it's very much around individual and ensuring that individuals have equality before the law, both in the criminal side and the civil side as well. And we have to hold on to those first principles, but we would recognise that yes, some compromises will have to be made, but ultimately we want to have a system that, where possible, ensures that people, particularly in the down on the luck, have access to justice, both on the civil side and the criminal side. It's going to be a hard circle to square, and we're going to have some hard debates in the coming months. We looked at what happened only last week with the Law Society's judicial review, and the Legal Services Commission were found very much wanting in terms of the administration of legal aid. You know, that will have to be sorted out. There's a lot of detail to be sorted out, but I would say keep your eyes on the principles of what legal aid is about. It is about access to justice. It is about equality before the law.
Thank you very much indeed. And our next speaker is Peter Lodder, QC, Vice Chairman of the Bar and a criminal specialist.
May I say straight away that I entirely agree that the starting point in this should not be lawyers' fees. I'd be surprised if any lawyer would suggest otherwise, certainly not on a public platform. but can we just set a little bit of the context of this? Lawyers can't operate where there are no cases to be done. And the reason that there has been an enormous growth in legal aid in the recent years has been because there's been an enormous growth in the amount of work that they have been asked to perform. There were, during the course of the last government, in excess of 3,000 new criminal offences created. You will know already, perhaps, that the prison population grew from 44,000 in 1993 to 85,000 now, each of whom cost the Ministry of Justice something in the order of £45,000 a year to house. And we have now a complicated system insofar as procedure and evidence are concerned. So that's why we've got more lawyers, that's why we've got a bigger legal aid budget. But the legal aid budget, in fact, just to return to the context that Jonathan set out at the beginning, is a pretty tricky one. The Ministry of Justice are being required on a 25% basis to find £2.25 billion. That is more than the entire legal aid budget. So scrap legal aid totally and you still won't meet the target. A similar cost is the prisons. And we have made for ourselves suggestions to the government that they may look at their prison policy and consider whether this is in fact money well spent. And so what we say is, yes, there is a difficult starting point. It isn't a lawyer's fee starting point. It's a big problem for everyone. And we would be very happy, and indeed we already have begun to engage constructively with the government. We find this government to be a very good, listening, responsive government, and we are cheered and heartened by it. And we are looking already at how lawyers deliver services, how they can deliver them in a way which is different, in a way which may afford the opportunity for the economies of scale, which Jonathan briefly referred to, the structures that we would need to do that. And indeed, we've made positive suggestions. We've invited the government, for example, to look at compulsory legal expenses insurance for corporate officers and directors. Mention has been made about the cost of fraud trials. Well, most defendants in fraud trials are officers of a company in some capacity or other. If there was compulsory insurance for each of those, which has been calculated not to be a particularly expensive per capita cost, then that would take out of the legal aid budget an enormous amount of money. We've also suggested market-based solutions for the civil legal aid area. We suggested investigation of the contingent legal aid fund and developments which have been considered in the Jackson report. And we also invite the Ministry of Justice to look at, for example, releasing frozen assets. Millions of pounds are frozen so that a defendant who would otherwise be able to afford a perfectly good defence is then forced into reliance upon the state. It seems to us to be an area which can profitably be examined. And we welcome the savings that the Ministry of Justice is making itself through administration cuts, the changes that have been foreshadowed by the last government to the Legal Services Commission, confirmed by this government, which involve getting rid of rather large elements of policy making and inviting attention to the core detail, taking the LSC as an executive agency back into the Ministry of Justice. There is, however, a danger, we fear, of there being more and more pressure for the provision of pro bono services, volunteerism as it is otherwise known. Volunteerism has been a conspicuous feature of the bar for well over 40 years. We've had FRU, we've had the pro bono unit. Indeed, on the 19th of October, the National Pro Bono Centre will be opened, and there has been substantial Bar Council support for that. But pro bono workers are those who have another income to support them. They need to be able to earn in their own right. And it is, in our view, very much a short-term attraction. And there is, we think, a danger also that you may find that if you lean too heavily on the third sector, then they may become somewhat disenchanted with what is being required of them. And so what we think should happen is there must be a joined-up approach, to use a phrase which has become somewhat blighted by its use by the last government. We wish to engage very much with the government to look at ways in which we can continue to provide our services in a more efficient way through the vehicles that we have been examining. May I just conclude with one further observation. As some of you here will know, many of those who come to the bar now with very substantial debts. They have had to pay for their university, they have to pay for their law school, and then they hunt around to find a pupillage. By the time they start, many are in debt to the tune of £50,000. Time was when if you had such a debt, it would not trouble you too much because you knew over the course of your career you would be able to pay it back. Now, that is not the case. Many students who come to the bar fear that they will not be able to repay such a debt if they go into publicly funded work. And so what they are doing is that they are either not coming at all, or they're coming to the bar but going into the more lucrative areas, privately funded areas, to the detriment of those who need publicly funded services. And very particularly, they are the people who did not come to the bar before, people from other socio-economic groups, from other ethnic backgrounds. And these people are dissuaded more than anybody else by these cuts. And it is, in our view, vital that representation must reflect the society that it purports to represent, and we do feel that that is an area which is deserving of close focus.
Thank you very much indeed. Peter's reference to pro bono takes us very neatly to Michael, whose firm who personally has contributed a huge amount to volunteerism through Clifford. I don't know if that's what you want to talk about, Michael, but the floor is yours.
Thank you, Joshua. Being fourth on a panel of four means that one's irresistibly drawn to, what was it, the Zaza Gabor comment on her fourth marriage. I know what to say, I just don't know how to make it different. You'll have noted that both Peter and Steve said this wasn't really about lawyers. Well, it is a little bit about lawyers, but in this context, that access to justice is an aspect of the rule of law, and upholding the rule of law is an express professional obligation on every lawyer in this country. So in that philosophical sense, this isn't a nice to have, this is an obligation placed on all of us. And you don't have to be a legal theorist in that context to be concerned that if anyone's denied access to justice by dint of an inability to pay, that there is a systemic and social problem to be addressed. Like any lawyer in approaching the government's proposals, I went to the source materials and I looked up the Spending Framework Review, which provides that any publicly funded activity must demonstrably provide substantial economic benefit targeted at those most in need and deliverable at the lowest cost by non-state providers to be funded on the results they achieve. Fair enough. In that context, some of the research produced by the Citizens Advice Bureau earlier this year suggests to me at least that for all its existing manifold, manifest flaws, the system already arguably produces substantial economic benefit in terms of preventing downstream costs in other parts of the welfare system. Steve talked about the knock-on effects of legal aid activity in other parts of the court system. What about other parts of the welfare system? The CAB suggests that for every pound spent on legal aid housing advice, the Treasury avoids having to spend £2.34 elsewhere. For every pound spent on legal aid debt advice, the country saves £2.98 somewhere else. And the New Economic Foundation has reckoned that the socio-economic benefit to cost ratio of the work done by law centres is around 15:1. Different measure, same broad result. And it's in that context that I dare say that a party that rightly balks at the reality that it costs more to send someone to prison than to eat them will want to ensure that the outcome of the government's review is not one where costs exponentially increase because of loading in other parts of the welfare system. So what's to be done? Like Peter and Steve, there's plainly a lot more original thinking to be done in the insurance sector. There's a statistic commonly produced about which I'm personally skeptical, but let's take it as true, that 28 million of us have legal expenses insurance as part of our household protection policy. That sounds good, that sounds like an area in which to start, but the problem is the great bulk of those 28 million people are already outside legal aid eligibility levels. What about the fact that around 30% of men under 30 in this country already have a criminal record and therefore find it very difficult to obtain insurance? So that's going to be another possible inhibiting factor. But no reason, on the other hand, it seems to me, why legal expenses insurance can't be made a part of social housing tenancy agreements. Work to be done there. Also no reason why the idea of a credit industry levy to fund discrete debt advice shouldn't be taken up. I can say that because I see Clifford Chance partner in 3 weeks' time. So the firm's banking clients will no doubt view my comments in that context. But I should say something about what Peter's described as volunteerism, what you referred to as pro bono. Joshua, I have throughout my career, charged fees which many have described as extravagant, but I've also charged no fee in many respects, and the legal profession in this country has a very proud record of volunteering activity. But I don't think anyone is suggesting, and to be fair, I haven't heard the government suggest that pro bono activity can be any real, meaningful, sustainable substitute for state-directed, centrally funded legal advice and assistance. Two modest proposals in that regard. Much pro bono activity is restricted to the rich law firms in the City of London. And if that's part of their license to do business, that's a burden that so far they've been willing to shoulder quite happily. But we're very, very far from having a national and sustainable pro bono program, and lots can be done in that area, not in order to move into areas which were once the preserve of highly skilled, technically proficient full-time legal aid lawyers, but to cover off those parts of so-called poor law legal activity that were never the subject of state-funded legal advice and assistance. And I think a proposal in that regard that's far from being radical would be that both sides of the profession exhort their members to do 20 hours free legal activity a year, 5 minutes each working day. Much of that's already being done, it's just not properly being captured as a statistical measure. And then I think much more can be done in terms of twinning arrangements, if you like, rich firms, poor firms. Again, not a program to drive legal aid practices out of existence, but to ensure that all their back office and managerial and other activities which aren't directed exclusively at the front line are removed from them as burdens, leaving the specialists to do what they're best at. And then finally, we've talked about the role of government, we've talked about the lawyers. What about the law itself? It seems to me any review that's comprehensive, Minister, should look at the fact that areas of poor law are immensely complex and have got exponentially more complex in the last 20 years, particularly, for example, in the social housing area. And if we're to have a welfare system as a whole which is simplified and is intended, because of the simplification, to secure popular buy-in, then surely a relentless law reform program of activity in this area is part of the mix. So summing up, I think everyone's got to give some to get some. The legal aid firms which are doing so much need relentlessly to keep eking out efficiencies. The private sector, of which I am part, needs to do much more, and government needs, above all else, I hope, to ensure that the cuts which come won't simply have the unintended consequence of increasing other parts of the welfare budget.
Thank you very much indeed. Well, all our four speakers have kept excellently to time, and before I open this to the floor, what I'm going to do is I'm going to ask the Minister to respond to the three people who spoke after him. This was at my suggestion rather than his suggestion, just
I have you taking notes.
Exactly so, but so have I. And the thing was that, and the thing is, and I'll just pick out a few thoughts which are bound to be in your notes anyway, but you might just like to cover anyway. Starting with Steve, he said that public family court system is in a mess, and we're going to have a review of that, and having a review of that, and we're going to have announcements on that in due course. But he said he thought that even if you were to cut money from private law, from divorce, particularly from ancillary relief in divorce, money when couples split up, that it was essential to keep funding public law, which means children being taken into care. And he was sure that you would prioritise that, and you might like to comment on that. Peter's got some very interesting points about compulsory insurance for company directors against defence for fraud charges. It wouldn't cost a lot of money, it wouldn't run into the problems that Michael discussed about people who wouldn't be eligible for insurance, because company directors would be eligible for insurance, and if they could be forced to insure, then they wouldn't need legal aid if they are accused of fraud. And his other interesting point was frozen assets, the assets of the company that are put into liquidation, or whatever the assets can't be used. Shouldn't they be spent on the lawyers? Michael also had some points about insurance there. Very keen to stress that pro bono shouldn't be a substitute for any cuts in legal aid. And finally, areas of poor law are too complex. I have a feeling that the Law Commission has put out some proposals on that. I can't remember if it's a discussion paper or final proposals, but it seems a very good idea to simplify the law, because if the law is simpler, it costs less for lawyers to do. So would you like to pick up any of or all of those points, Jonathan?
Well,
take it from there.
I think it'd be fair to say, Joshua, there's quite a lot of points there, and I'll do my best. I mean, to start off with Steve's overall point, which was a fair one, that to the extent to which, I didn't come up with firm proposals, and as he will know, ultimately the Green Paper has got to be announced to Parliament, and it will be so this autumn, and we are in the autumn, so that's quite imminently. But the application of it, like actually you mentioned, was private family law versus public family law. What I would say there is that the big difference between the two is that the ECHR tends to attach more to public law than it does to private law, and so there are a different series of considerations that come up between the two. That's the most dramatic difference. But Steve, you then went on to develop your point by saying that ultimately people are going to have to rely on lawyers. And I think to some extent we do need to evaluate that, because even if, for instance, we're not going to dramatically reduce funding going to public law, say that was the public family law, say that was the case, that doesn't mean that we shouldn't, within that, look to make the system more efficient. It may be that there are certain elements of public family law where the systems are too complex, where the some aspects of the system that works between the courts, CAFCAS and social workers is actually overly bureaucratic and could be made more simple. So there's a lot of room for making things simpler, and I think for finding savings at the same time within the overall context. And at the same time, I would say that we do need to look at the system of law that we have in this country itself. The fact that too often people in this country want to rush off to court with their winner-takes-all mentality, and it hasn't been mentioned yet, but I think it's a good context to mention it, that we do need to look at alternative systems. In certain circumstances, it may be that a more inquisitorial approach rather than adversarial approach is more appropriate. It may be that in certain circumstances where it's a very simple issue, that it could be dealt on an administrative basis rather than a court basis at significantly lower cost without perhaps legal representation even in certain circumstances. And it may be that in certain circumstances the case is more suitable towards ADR rather than rushing to court. And I think we're much too weak in this country on ADR, and we are looking very carefully at ADR, particularly mediation. And there may be circumstances where that should be the first rather than the second thing to look to. So there are a lot of variables here that we are looking at in the context of the Green Paper at the moment. On the question of insurance, I think Peter made a very good point here. He mentioned it specifically in relation to criminal behaviour, criminal activity. We also see it as being very relevant to civil. At the moment, we have a system based predominantly on CFAs, no win, no fee, which involves normally the claimant looking to cover the possibility of them losing and being hit for costs and taking after the event insurance. And as everyone will appreciate, Lord Justice Jackson has suggested that should be removed on the basis that it ramp ups the costs of litigation. And we are looking at that. But the flip side to that, as Peter mentioned, is that actually perhaps people should be more proactive in taking insurance to cover themselves in the first place. And so we are looking at the before the event market for insurance, and that will be covered, I can say, in the Jackson Green Paper, which will be coming out very shortly as well. Both Peter and Michael mentioned pro bono. The government is very supportive of pro bono. I'm personally dedicated to encouraging pro bono, and have been for a long time, by the way, so I'm not new to this. I agree that it should be developed. I've had discussions with the Law Society recently, and I know that they are very much of the view now that it should be encouraged as part of a solicitor's overall practice development. And I know there are proposals to develop it not only with the larger firms, which was the point Michael quite rightly made. It has historically been larger firm dominant, but actually it should be broadened. I agree with what Peter said. I would make one point though, that I think it's not just relevant to those in practice, and I think you said it mainly is. What we're actually finding is that it can be a very good filler for those who are actually out of work, to keep lawyers in the frame, if you like. It can actually be very good for them to go down to the CAB and offer their services between jobs, or indeed for those, particularly women, who want to get back into the legal market after maternity. We're finding there's an increasing role for pro bono there as well. The complexity was mentioned by Michael quite rightly, and I agree that if you want bringing in the conservative game plan, we're going to move to our big society, a society in which people take more responsibility for their own actions, and look towards things like mediation and sorting out their problems between themselves. And by the way, where people do go to mediation, the satisfaction ratings are very high, 70–80%. And if we're going to increasingly encourage people to go to mediation, and this is something we're looking at very, very seriously, then we do need to, I agree, improve not only access to mediation, but also reduce the complexity of the systems. Because if we don't reduce the complexity of the systems, your normal person will have to, in the event, go back to the lawyer. So that, I think, the reducing complexity of the system is a very important point.
Yes, you have. Well, there's one question I want to pick up with you, and then I really will answer, hand it over to the floor. You said don't encourage people to rush to court, and you mentioned mediation and alternative dispute resolution. I can understand that. But you also mentioned the idea of a more inquisitorial approach, and you said it could be done on an administrative basis, perhaps with no lawyers involved. Can you give me some examples of your thinking?
Well, I mean, the inquisitorial approach is not necessarily to be lumped together with the administrative approach. I mean, the administrative approach might, for instance, be a tribunal rather than a court system, and an inquisitorial approach could be in front of a judge rather than a tribunal. So they're not necessarily to be lumped together. We just think that in certain circumstances, a less traditional confrontational English type approach may be suitable, and certain family law procedures actually shoot to mind. But more, perhaps a little bit more of that in the Green Paper.
All right. I won't put you would you like to stand up? Would you like to give your name? I don't think there are microphones, but just shout out.
My name is Sonia Skeets, and I'm here representing the Medical Foundation for the Care of Victims of Torture, which is a human rights organisation and one of the largest torture treatment centres in the world. As an organisation, we've benefited over many years from the pro bono services of Clifford, so thank you very much to my colleagues in that area. My question is about our clients. We represent we provide services to some of the most vulnerable asylum seekers, and you can imagine very complicated cases. And we found that the closure of refugee and migrant justice has hit our clients. We've had over 200 clients who were left without representation and who are still struggling to find representation for. And I just sort of was really heartened by what you said in your closing remarks about the starting point for the review being to achieve a system in which vulnerable people have the legal representation that they need. And I just wondered what thinking is going on in your department at the moment about safeguards that we can deliver in the field of immigration for clients of ours and for other vulnerable types of asylum seekers. Thank you very much.
Thank you for bringing that up. And sorry, please do. I mean, you mentioned the Refugee and Migrant Justice Organisation, who've done a lot of good work over many years. I think they were the second largest provider. It was very sad to see their demise, and as you all know, they did ask the department to fund them. But ultimately, when you get an organisation asking for money to pay their last 2 quarters' rent, and it was a very significant amount of money, and we have to decide, does that go to paying their rent, or should we have that money going to pay for immigrant advice, asylum advice? Then that was really where we had to come down, but we did put a lot of effort into making sure that their clients were transferred to other organisations, pretty successfully, I have to say. So it wasn't a happy episode, but it was dealt with. As to the wider question of how we're likely to deal with funding refugees, asylum seekers in the legal aid review, I'm afraid that you'll have to wait for the brief paper. Okay. But it is being considered.
I'm going to go straight to the next question. Fred.
Thank you very much. Fraser Whitehead, I'm a solicitor in private practice. It's for the Minister, 2 points really. Both widely out what he said in reply to Joshua's area of interest. The first about legal expense insurance and CFAs. In his report, Lord Jackson, in his last report, actually suggested that if CFAs were abolished, we could alternatively look at what he said in his first report, which was having successfully staged AT premiums recovery, and I hope that the government would be looking at that. He also indicated in the context of legal expense insurance that the product wasn't in its present state quite fit for purpose, and I'd suggest to you that if you're looking at this, and it may well be a solution, there's 4 things about legal expense insurance that have to be tackled. The first is, it's got to be a real insurance. At the moment, it's a free or an add-on. It could be described as a pretty tacky product, and it needs to be real insurance for real risk. The second is the inherent conflict that can arise out of a conflict of interest between the solicitors appointed to act and the legal expense insurance themselves about whether there's policy cover. And thirdly, the use of panels, which questions the independence sometimes of the solicitors acting. And fourthly, there's the inherent contradiction where many legal expenses insurers are actually liability insurers as well. That has to be addressed, and perhaps those offering legal expense insurance should be limited to those who only offer legal expense insurance. The other point I wanted to take up was about what I understand is being thought about, that from the experience of clinical negligence cases, there's some interesting statistics emerging about the way in which CFAs involve costs compared with the way legal aid cases involve costs. And I just wondered if you could tell us what indicators that was showing, what direction that was going.
Sorry,
where clinical negligence costs supported by legal aid on the one hand, or CFAs on the other hand, were producing different statistics. What was that difference?
Okay.
You, I'm afraid.
Right, well, I think, to take your last point first, you highlighted a very important issue, which is that you can't look at CFAs purely in the context of CFAs. You have to look at it in the context of legal aid. And at the moment, you mentioned clinical negligence, that's 50% paid for by legal aid, 50% paid for by neighbouring review agreements. So, and this became very apparent that we couldn't look at one without the other. So, which is why we were very keen that the Jackson Green Paper should be running at the same pace as the legal aid Green Paper, which I'm pleased to say is so far happening. and I intend to keep it that way, so that when the 2 Green Papers come out, people will be able to look at them in context and see that, and we will be very interested to hear people's views on the knock-on between the two. As to insurance, well, thank you for those valid points, and please do make them in the consultation when it starts. I do take your point on the add-on. I mean, in reality, I think sometimes those add-ons are better than others, and people are going to have to get more used to actually reading what's in the add-on. I think most of the add-ons now would be when you've got your home cover or your car cover, and I wouldn't imagine most people look at it very carefully, but we do want to encourage a market where people do look at it more carefully for the reasons you gave.
Okay, I don't want to ignore the rest of the time. A lot of people have questions. You had go ahead. Yep.
Hi, I'm Councillor Natalie Hynes. I'm also a barrister in practice. I was very interested in listening to what I listened to, where we had a comment saying it's not about the lawyers, it's about access to justice. So recently we had an email going around asking if we wanted to give some representation, and I believe it was a judicial review, and it was to do looking at family legal aid. And the potential outcome of that was that there would be only a few handful of firms that would end up doing legal aid. So I just want to consider whether if you end up with fewer law firms who are then doing legal aid, whether that then doesn't push up what they're able to demand in terms of what costs, what it costs to provide legal provision, legal services for clients who actually need legal aid in the long run, because then fewer people are able to actually do the work. Then, in terms of ancillary relief, when couples are getting divorced, my understanding, I do believe there's a threshold. Represented a client who didn't qualify, he said her income was a little bit over, so she didn't get the legal aid. But I understand that that can also be recovered when they end up selling their assets, the house or whatever, that legal aid then can be recouped in those sorts of cases where legal aid is provided. But also,
that's probably, I think, enough, unfortunately. Yeah. Steve, I think I'm going to ask you to comment on this first before the Minister.
Yeah, can I make another comment as well?
Very briefly.
In civilly, the frozen confiscation orders, they've been made as well. I'm just wondering if that's another area. What happens to the money where the money can be recouped from frozen from people who are under criminal charges? A lot of money can be confiscated if they can't account for the Proceeds of Crime Act, proceeds of crime. Are there a lot of assets that is frozen in some fund? What can be done with that?
Okay, thank you very much indeed. Steve, do you want to?
Yeah, just a couple of points. The danger, if you reduce the number of firms, is right. You can potentially reduce cartels, and this was the experience in North America. LAG did a report 10 years ago on this and explored that point. However, the point I'd make on the JR is this, that it didn't turn on the access to justice issues. We very much supported it on the access to justice issue, but it was very specific to the selection criteria. And I'd say this, that potentially you could demonstrate that you still have access to justice with 1,200 or so family law firms. It's not about the number of firms, it's about ensuring that people get to a lawyer when they need advice and there's not conflicts of interest in local areas. So, we shouldn't confuse access to justice with the numbers of law firms, though yes, that can be a factor. But I suppose the final point I'd make on that is that clearly there are other access points. There's citizens' advice, there's other NFP organisations, there's obviously the internet now, and whole raft of type of referral agencies. Because LAG are very conscious that we have something like 1,400 or so family firms back in the system, but we have less than a few hundred housing firms. We have less than 100 probably firms that specialise in community care law. So there's lots of areas of law where there aren't the numbers of firms perhaps to service the area of law, but people do manage to find their way eventually to the right lawyer. I think certainly with barristers and it being a reformed profession, although it is changing, and that's much what solicitors do in those specialist areas. They ensure that they get to see a barrister that they need.
John, you can say I agree and have nothing to add? Or?
Well, I would just make the point that on family legal aid contracting, I think, firstly, this is a system that was, the contracts were arranged in 2006. It went on for a long time, and we will have to look at the JR decision to see where we go from here. But we will look to learn from it. But I have to say that doesn't mean that contracting is going to stop. That's where we are, and I think it's important that firms appreciate that. I think they do. When I speak to the Law Society and the Bar Council, they know which way the wind's blowing. And there has been, quite apart from what government's doing or going to do, not least because of the recession, there has been a lot of merger and consolidation of law firms and bar chambers over recent years. I think that's going to continue. I think the move towards alternative business structures is probably going to accelerate that process. When contracting, the next round of contracting comes in place, I think there will be less firms. But importantly, there were not less contracts. There was not less legal aid being provided. It's just going to have to be approached by firms in a different way.
Who decides whether there's an appeal against the decision last week in the High Court? In other words, who is running the MSC at the moment? Is it the board, or is it the chief executive who's an official in your department, and therefore is it you?
No, the chief executive is not.
So not chief of the.
No, it's a separate non-departmental public body,
Okay.
which means that they have a commission. There's a series of commissioners who they're not.
She's seconded from your department, but she still answers to the board, so they're still independent.
The commissioners, they're independent.
Yeah.
The choice as to whether they appeal it will be absolutely theirs. They will not.
Okay, Peter, do you want to?
Yes, but might I just pick up on one point? What emerged quite clearly from the family contracting procedure was that there was an unintended consequence, and the unintended consequence was that a vast number of quite small but highly specialised and much valued firms lost their contracts, and so the number of firms available was very dramatically reduced. And I don't. This was not what they planned to do. It's how the process actually came through and what emerged from it. And that gave rise to much of the criticism found justified by the court that it was an irrational process. We are very keen to become involved, the Bar Council is very keen to become involved in the contracting process. I think we all need to learn from what has happened to those family solicitors. That process has got to be a fair one, and it's got to enable people who have real value in the legal services market to come through, and not be an arbitrary one which simply effectively looks at who's got the best economy of scale, let's have them, and it doesn't matter about the quality of the service.
Gentleman there, sure.
James Sandback, Systems Advice. I'm delighted that Michael picked up on the Secretary of Systems Advice earlier this summer about the return you get on social welfare law investment and expenditure in the long run. And I mean, there is something of debate going on at the moment about where social welfare law fits in the system. Is it should fit within legal aid and seem to be in scope, or be funded through other mechanisms or delivered through other mechanisms? But you know, very, very clearly from the research we did, that if you take this long view about how much savings can be achieved at other parts of the public sector through early intervention advice, it is something that's worth funding. So I'd really like to sort of poll the Minister a little bit about what the kind of current thinking is about social welfare law and where it sits within the system.
Mike, do you want to come in on this before the Minister replies, or do you want to hear the Minister and then you reply to him?
No, nothing to add.
Okay.
No, I can just say that we're looking at it as part of the.
Lady there.
Claire Palmer, criminal barrister. I don't know whether we should be heartened by the fact we focused on civil, and perhaps that's where the bulk of the cuts are. But that's not. I was very interested in particular points from Peter and Michael about the impact of particular decisions and the number of people getting criminal records. Quite rightly, the system is geared towards those facing prison sentences in custody and the loss of liberty. But I think it's very important we don't underestimate the massive impact a criminal conviction can have. And I'm slightly concerned, Jonathan, about the move away from jury trials, particularly when you look at the conviction rates in the magistrates' court, which are overwhelming sometimes with court clerks who push through a process where defendants even represented, that the systems aren't always followed through. And I think if you're going to do that, that is going to have a huge impact on people, on their employability as well, because with a criminal conviction, you're not going to be able to get out to work, and the impact on the social welfare budget in order to perhaps.
Claire, that's a very fair question, and one that we are thinking hard about. But what I can say is this: is that when I went to a Crown Court a couple of weeks ago, and a judge sort of put his head in his hands, and he said to me, "I've just had 2 cases in a row. One was for this £14 sale of a theft of a £14 coat hanger, followed by a single wrap of drugs. Both, jury trials. Juries are people who give up their time as a civic duty, and it wasn't just the judge who was disgusted that this has come to his court. He said, "What about these people who are giving up their time for jury?" So I think you can be totally committed to jury trials, but just realise that actually, it's put it as 80% of theft trials in Crown Courts are for a value of less than £200. And for each of those trials, they're costing £17,000 instead of £1,700. The legal aid costs are 4 times. It gets to a stage where we actually have to look at value, look at whether juries is a good use of jury time. I mean, it is a financial issue, but there are more issues than the financial. And this is one of the reasons why it's so important to look at sentencing review, which is being done on the other side of the department by Chris Blunt and Nick Herbert. It's very important that their review is going on at the same time as my legal aid review and courts reorganisation review. All these things are happening at the same time because they all tie in with each other.
Previous governments have tried to abolish jury trial for low-value theft, and they've got into difficulties unsuccessfully.
Yeah, there are various levers. I mean, people often jump to changing the either way offences, but actually there are other levers as well, including how legal aid is handed out, and including discounts. So you can look at it from the point of view of what courts it should go to, from an either way point of view. You can look at it from a public funding point of view, and you can look at it from the view of giving encouragement to the defendant to plead the right thing at the right time. There are various levers, and we're looking at all of them.
A gentleman from
Yes, hello, my name is Richard Jackard. I'm from Dulwich and West North constituency. Perhaps one of the only people in the room not legally trained, so you'll forgive me if I mix up terminology, etc. I'd just like to pick up on Peter's points, which was very interesting, which was about meritocracy, which was really about access to a legal career, access and flow of graduates, etc., qualified people into pro bono, into public law rather than more lucrative private law. What can be done? Well, first of all, Jonathan, what can be done, from a legislative perspective, from a promotional perspective in general, to ensure that meritocracy occurs rather than pure, sort of previous government attempts to sort of, impose quotas, etc. What can be done to ensure that people, irrespective of the background, who don't have access to funding or parents' funding, etc., to gain entry to such legal careers, what can be done to stimulate that? And furthermore, Peter, what would you like to see on the other side? What would you like to see the government do to stimulate that?
Well, I'm not sure that it's particularly easy for a government to legislate in that way. And so I suspect the question of Jonathan might be a difficult one for him to answer. From our point of view, we have had considerable success as a profession in my lifetime. I remember coming to the bar, not from the right school or right university, and being told when I considered going for a pupillage in particular sets of chambers that I wouldn't get into those chambers because I didn't have the ability to tick those boxes. I didn't come from a legal family, and so it was effectively blocked. Over the course of the time that I've been at the bar, that situation has changed totally. And now, if you are able, you can practice at the bar. It is subject, obviously, to finding the opportunity to get going, but other than that, the opportunity is wide open. And so the bar now, in its lower echelon, not at the top, because they're of my generation, but the lower echelon of the bar is a very diverse group indeed. And it doesn't matter if you were born in a chateau or a council flat, you can get in. What my fear stems from is that the people who come from the council flat background are the ones who are carrying the heaviest debt. They don't have the parents who are going to bankroll them, and so they will come to a point where, however bright they are, they're going to be looking at the future as a publicly funded practitioner, and they're going to say, well, I'm too much in debt already. I simply can't do this. I will have no income to match the debt that I'm already carrying. And that means that the diversity that we've achieved, the system, which means that you can be represented by someone who reflects the society you come from, which I personally think is an extremely good thing, that will begin to break down. Now, there will still be some people coming through. It won't change utterly to go back to where it was, but it will, I think, be a retrograde step for the profession as a whole. What can we do? Well, we do as much as we can at the moment. We have a system whereby all pupillages are now funded, and we offer generous, or as generous scholarships as can be made available, but that is not so big that it can cover a £50,000 debt.
Is there anything you want to add?
Well, I mean, the government supports diversity in the law, and we're very encouraged by hearing things like we've just heard from the Bar Council. I mean, I believe it's the case now that there are significantly more women going into law firms than men. The profession is changing. The shape of the profession in terms of gender is changing dramatically, very quickly, and that's great. As to the number of lawyers, which was sort of the other side of what you said, I mean, I don't think it's really for me to say how many lawyers there should be. I can tell you that 30 years ago there were 4,500 barristers, and now there's 12,500, so it doesn't seem to be an immediate decline. And I know that in the last year, I heard from the Law Society last night, in the last year, I had assumed that the number of solicitors would have fallen. It actually slightly increased at a time of recession. So, the people are still coming into the profession in numbers, and and that is, the market will set the amount of work for them to do.
Michael, correct.
Just very quickly, I wouldn't be quite as confident as Peter in terms of the picture, in terms of recruitment to the profession. A substantial inquiry was conducted into this last year by, dare I say it, at a Tory conference, Alan Milburn, who found that diversity in the legal profession in terms of social mobility is trending backwards, and that my generation of city law firm partner who came through in the 1980s is not being reproduced in the same numbers, and that's a function of issues around our educational system, the university experience, and the way the university experience is funded, and therefore, for sure, a firm like Clifford Chance is much more racially heterogeneous than it was when I started, but the one element in the diversity picture which seems until recently to be missed when talking about the legal profession is class, I'm afraid to say.
Which is important.
Peter, what's the bar doing?
May I pick up on that? Because although I indicated what the bar is trying to do to stop this problem becoming more serious than it already is, the fact is that pupilages have dropped, and they have dropped every year for the last 2 years, so that they're now a third down in the space of about 2.5 years. And so there are not the opportunities, and that is directly affecting those who come from the lower socioeconomic groups, because the non-availability of pupillage is within the publicly funded chambers more than it is in any other area.
Yes, Laura James from the Young Legal Aid Lawyers and also Solicitor for Children at the Howard League Female Forum. I must just comment on the last topic, because Young Legal Aid Lawyers actually produced a report with lots of ideas as to what can be done to promote social mobility within the legal aid sector. And the research shows that while the glass ceiling, certainly for women, has cracked at entry point, what you have is a concrete ceiling about 10 years down the line, though, of course, as the Minister suggests, we could do pro bono work after maternity leave. As a young mother, I think that.
Take it how you like.
My taking points, one is we've been in this room talking about legal aid for over an hour now, and nobody has mentioned quality. And really, that's an enormous issue. My organisation is Young Lawyers across the bar and solicitor sector. Young lawyers are being forced to come into a situation where they are literally being forced to do poor quality work. There are firms that are using the fixed fee system and opening and closing cases without merit. Poor representation, we say, is worse than useless, and I would like some assurances that the new proposals will put quality at the very heart of legal services. And the second thing, of course, is going back to this very important rule of law point, and for the rest of your policies and your laws, no less, to have rigour. Legal aid is perhaps your most powerful ally, and as a solicitor representing children in prison, I had an example only last week which is absolutely terrifying, of a child, very high risk child sex offender, who overwhelming evidence that what he really needed at this point was treatment in the community. That treatment was available, but of course the local authority really did not want to fund it, and so he will remain in the criminal justice system. He's already cost you over £500,000. He will cost you more, and he will probably come out, and the evidence suggests that he will come out and he will rape children if he does not get the treatment he needs.
And that's a very, very serious concern. And these proposals must send the right message that whatever happens, the rule of law will not suffer for want of good quality representation.
Well said.
Yeah, they do.
Yeah, well, very fair points. And on the quality one, I think you actually mentioned quality in two contexts. The first context was the people getting poor quality work. I mean, that is partly internal to the relationship you have in your chambers with your clerk and so forth. It's not, but also in the wider context of quality, the quality of work. Contracting and barristers getting together to contract the work will enable them to take their lives into their own hands in a way that's never been possible in the past. Rather than having things handed to you by solicitors, you will be able to hand things to solicitors potentially. So, but the other important point on quality is the quality of lawyers. For instance, how good should a lawyer be to bid for a public contract, for instance, for a legal aid contract? And I have been giving some thought to this, and I'll give some more thought to it. But I would make, I would make the point that ultimately, is it for government to be telling the legal profession who's a good lawyer and who's a bad lawyer? And to some extent, I think it's we've got in place a new regulatory system. And it's the regulators really who should be saying who is acceptable to practice or not practice, rather than it being for government to take control. And finally, you also came up with a very good example on we accept that rehabilitation in this country is not in an acceptable position, which is why we're doing full review. This isn't me personally, it's the other side of the department. And that is going to be, we do want to totally revolutionise rehabilitation. And we will have to watch our proposals.
Now, I was told we ought to finish now. As far as I'm concerned, we can go on another 5 or 10 minutes. If the panel's ready and the audience are happy. Should we carry on? Yeah? Everyone agree? Carry on? Right, okay, Leslie, your question.
My name is Leslie Perrin. I was the senior partner and managing partner and commercial litigator at Osborne Clark. I'm now in a portfolio of directorships associated with the financing of the legal process. I'm a non-executive director at DAS, which is not only the market leader in legal expenses insurance, but far and away the market leader in legal expenses insurance. And my saliva ears have been thoroughly tickled by all the places into which we can expand our services. I'm also chairman of a third-party funding organisation called Colunius Capital. Now, Jonathan, I can save you whatever your civil legal aid budget is spending on those clinical negligence cases, because they could be given to the market as the market now exists. But Jackson is simultaneously planning a wholesale transfer of the burden of the costs of our civil litigation system from the defendants, for whom he acted characteristically throughout his career, to the claimants. And that would be it would be a very, very bad time indeed to be withdrawing legal aid from a section of the clinical negligence claimant community at the same time as you are transferring the burden of the cost of that from the tortfeasors to the claimants themselves. And I think you've got a real opportunity there to let the market carry away from the legal aid fund a chunk of its obligations. But at the same time, you're considering reforms that might just make that more difficult. So just a circle to be squared again.
Okay, before I bring you in on that, I'll bring Steve in for a word.
Yeah, sorry Leslie, don't get too excited about what you can pick up from the legal aid fund. Medical negligence costs about 25 and 30 million a year, depending on obviously which year. And what's been left from the legal aid fund is those difficult cases. Derry Irvin, maybe I shouldn't mention his name in this context, but he had a good go at bringing no win, no fee to replace a lot of civil litigation in the legal aid system. One of the areas that stayed in was clinical negligence, but what we've seen is the market is actually taking up the more lucrative cases, and what's left is the more difficult cases that are front-loaded with a lot of fees in terms of experts to investigate. So I'm not that confident that no win, no fee, or whatever the Jackson reforms come up with, because obviously this is another green paper, will take a big burden out of the legal aid fund. There could be some taken out. And in the other areas of civil litigation are areas such as housing, one of the biggest ones after family. I don't think there's going to be a massive insurance market for that. Areas like employment law only spend 6 million now. There's a lot of before the event insurance now covering employment law. I do think actually the market is made inroads to areas that previously might have been covered by the legal aid fund. So, nutshell, we're talking tens of millions and small tens of millions in terms of what the insurance solution would be. The other point to make, I think, picking up the point that was made before, the other jurisdiction to look at is Germany. And middle-class people in Germany litigate when something goes wrong because they're covered by legal expenses insurance. However, it doesn't cost 20 or 30 pounds on top of your car insurance or your house insurance. It costs more like 300-400 euros, which is probably the real market rate.
Yeah, well, I agree with what Steve said. I mean, the issues that you brought up, Leslie, are exactly the ones we're looking at. I mean, there's always a balance here. There's always going to be a winner and a loser. And the question is to find a course that is going to keep more people happy. But the Lord Young report just came out, and I think it is generally accepted by the majority of people at the moment that there is too little risk in litigation for the claimant. And by that I mean that ultimately, if you have no risk at all when you go to court, because when you lose, the insurance is going to cover your costs, and if you win, you don't care that your lawyer gets 100% markup because it costs you nothing anyway. We have a system at the moment that is too claimant friendly, and it needs pulling back. Now, you said that Jackson is only moving it one way. Well, actually, he does have some proposals to readdress the balance. Qualified cost shifting comes to mind, but I think there are other things as well. And we're having to weigh these things up, and it's going to be an interesting read paper.
Gentlemen here, and we've been waiting patiently, so
My name is Nick Wolfe. I'm also not a lawyer, but I am the honorary treasurer of my local law centre here in Birmingham. We've been suffering, finding it very, very tough to survive the contracting regime of the Legal Services Commission. And I'd just like to say that, first of all, social welfare law, the areas of law that we cover, poor law that it was referred to by somebody here, has always been the Cinderella of the system. I think there's about £130 million of the £2.2 billion of legal aid is spent on social welfare law. And yet, that is where there are all sorts of downstream benefits for the work that we do, stopping people, helping people to prevent homelessness, helping people with debt problems, helping people with problems at work and so on, and also housing, of course, is a very, very important area. I'd just like to say that I believe that there is a big society solution to the situation we have in the civil legal aid and social welfare law. When we started law centres 30, 40 years ago, we were pretty much pioneers. There wasn't a lot going on. Now we've got actually a fantastic potential network of providers. We've got 2 national networks, the CABs and Advice UK, providing a very wide range of generalist advice. We've got still more than 50 law centres around the country. We've got a group of dedicated legal aid practitioners in the private sector through LAPG. We've got specialist providers such as Shelter, Liberty, and a whole number of others. I do not believe the providers are the problem, and yet the civil legal aid is in crisis. And I would say there is a big society solution. I think that if a group of sensible civil servants sat down with the providers, we could do a damn sight better than the LSC, who I believe have made a complete mess of this contracting system. They cost £125 million a year to run that organisation. I think it is a failed organisation. I think it has completely failed in its duty in its job of trying to procure legal aid in an efficient way. The sooner it's abolished, the better. And I really urge you to look at alternative ways of delivering, particularly the legal help side, which is not the kind of court-based, but the legal help system. All those people I've just talked about are also more willing than ever to work together in partnership. And of course, we've got this burgeoning pro bono movement in the private sector. And of course, we've also got in the student law clinics, a whole series of student law clinics where law students are getting involved in pro bono activity.
Okay.
So please, there is a possibility there.
I think
much more imaginative.
I think you're preaching to the converted. That was the last question, and this is the last opportunity for all the panel to respond. Michael, would you like to sort of respond to that, or anything else that
well, I think that was a terrific contribution. I agree with all of it. And add this small detailed rider that some small element of capital expenditure in the coming period might be directed at technological solutions so that advice can become smart advice. If Professor Richard Susskind was there, he would say this could all be cured by web-based technology. I'm not sure I agree with that, but plainly there is much more unexplored investigation to be done around the technology space.
Thank you, Peter.
I think the one thing I'd like to say is partially in answer to the lady who stood up at the back and was talking about the difficulties that many people have when they are, albeit defendants in a system, vulnerable themselves. And I think there's a great concern, which is presently, my impression, not really catered for people who come out of prisons. They've been put there because there is nowhere else for them to go. They come out without any sort of real support structure, and they're so often doomed to return. And I heard a story recently from someone who had formerly been the governor of Brixton, who was speaking of an inmate who had been released. He'd been given some money and told to go somewhere. He got to where he was supposed to be accommodated for the night. They said they knew nothing about him, so he went back to Brixton and he slept for the night on the bench outside the main entrance until the warder came on for the next day's shift, and they let him in and took him back into the prison and kept him there, gave him a cup of tea and some breakfast whilst they ran around to try and find him somewhere to go. Now, if that's what happens to people when they come out of the system, when they would try at least to stay on the straight and narrow, but they are not being supported, then I think we've got a big problem.
Steve?
Yeah, next question actually made me think of somewhere not too far from here, Coventry. I've got a really interesting mapping exercise. What the local authority there do is they map the needs by wards, and they've come up with solutions for their advice services around internet-based services. So, for example, in the more prosperous wards, they're targeting services that are internet-based because, of course, as everybody knows here, generally people in upper income brackets and middle income brackets, they have access to broadband, and people in the lower income brackets do not. So they've tailored some of the face-to-face advice services into wards where they know there's not internet access, and people need that helping hand of face-to-face work. So I think there's a great potential there around the big society agenda to better tailor services to what people actually want. And yeah, not necessarily what lawyers want, but what people need in their local community. The other thing, it's a naked plug, we've got a conference on the 12th of November, and these are sorts of issues that we'll be talking about.
John, last word.
Okay, well, firstly, I mean, you'll be pleased to know that we have already announced that we are getting rid of the LSC, and it's a question of how and when we merge it into the department, because it does need primary legislation to do that. I think that you made a very good point on the huge number of different organisations, and it is a confusing patchwork. So, for instance, if I take my own constituency, I have 3 CABs in my own constituency, but none of them get a penny from the Ministry for Justice because the walk-in centres are not funded by Justice. If they were doing legal aid work, then they would get legal aid contracts. They would be. But most CABs or voluntary sector organisations are funded by local authorities. I think CAB centrally is funded by actually Department for Business. So we have seen this as an issue in terms of we need to see what we've got and how we best use it. And the rest of the panel will be pleased to know that we do see technology as being very relevant to that process.
Well, thank you very much. You've been an excellent audience and an extremely good panel. I'm particularly pleased the Minister has been so frank and so willing to take all your questions. I'm sure you want to thank the panel very much.